Great. Thank you, everybody, for joining us here for afternoon number 1 here. The panel, we're going to have a discussion about best practices for multi-defendant life sciences patent litigation. So the goal here is to talk about those things that can go right, those things that can go wrong, and those things that maybe you should try to avoid altogether to the extent that you can afford to when there are multiple defendants involved in a case. And I suppose necessarily by explaining the horror stories that happen with defendants and the problems that they have, we will have some insights into what patent owners or plaintiffs should be doing to put defendants in those compromising positions. So let me begin by introducing the panel. Again, from your left, the audience's left to right, we have Joshua Harris, who is a senior vice president from Burford Capital, and prior to joining Burford, he was a patent litigator. Next to Josh, we have Phil Johnson, who is currently chair of the steering committee for the Coalition for 21st Century Patent Reform. He is former chief patent counsel, chief IP counsel, chief of policy and strategy for Johnson & Johnson, and prior to that, he was a litigator for many years. Next to Phil, we have Brandon Helms, who is a trial attorney and partner at Addy Hart, and prior to joining Addy Hart, he spent time as an assistant district attorney, and he also, at the beginning of his legal career, was doing patent litigation as well, which is where he finds himself back at now. And then last but certainly not least is Stephanie Savinsky, and she is a partner at Haynes & Boone. And I've been trying to get Stephanie on a panel for a long time, and when Vince called me and says, hey, do you have a spot for Stephanie? I'm like, yes, absolutely I do. So I'm glad that we could finally make this work.
Me too.
So maybe what I will do is I will let ladies go first with your preliminary thoughts.
Okay.
When we hear the topic multi-defendant patent litigation in the life sciences area, and knowing we want to talk about what goes wrong and how to avoid what goes wrong, what is the first thing that comes to your mind that you want to share with the audience to prime the well?
It was funny that you said we could maybe draw some thoughts about what plaintiffs can do. I think sometimes in joint defense groups, defendants maybe are their own worst enemies because you have the added layer of having to work together with a whole lot of people whose interests may not be aligned with your own. And I think that was one of the core concepts we talked about in our planning call was a lot of the logistics of dealing with a multi-defendant litigation is driven by where are everyone's interests? What are they? Where are they aligned? Where are they not aligned? And how do you work through that? So the first thing that comes to mind in joint defense groups is that you have the awkward phone call where once a week you all just sit around in silence waiting for everyone to pick something up. I see nods. I know that some of you have been on these kinds of calls. So from my perspective, the greatest thing that I think you should try to get ahead of is the inertia of everyone just looking around the joint defense group call saying not it, and how to figure out what's important to your client on the front end.
Great. Brandon.
Yeah. So along those lines, in these cases, confidentiality can pose problems for you. Even when you have 2 or 3 or 4 law firms that are trying to be transparent and try to work well together, even with 2-tier protective orders where you have 1 tier of outside counsel's eyes only, you still have clients who don't want even the other law firms to know what's in their proprietary information, whether it's an ANDA or something else. And so we'll talk more about this later, but trying to have trust with your co-defendants and discover what might be out there that could harm you can be difficult to do when the client doesn't want other clients to know or other defendants to know what's in their proprietary information.
Great. Thanks, Phil.
I think there might have been an assumption that we're talking more about Hatch-Waxman litigation where you find yourself sued by a brand. But there are lots of different forms where you can have multiple defendants, and to some degree that's within the control of the plaintiff, who obviously decides when they're going to sue. As a plaintiff, you have to decide, do I want everyone together and have in front of one court, and can I get everyone together in front of one court? Or do I want them to be sequenced differently or located differently? Do I want to sue everyone I can sue at once, or do I want to start my suit against a defendant that I think will have to settle quickly or be a bellwether to the rest of the industry? So you have a lot of choices, and whether you're in the same court or not, if you've been sued by a plaintiff, you may want to coordinate with other defendants, and so that adds an extra layer of complexity. But we'll just leave it at that for now.
Okay, great. And Josh?
I'll see. I don't know that I can wrap things up, but I'll see if I can bring it full circle here. As a litigation funder up here, I think folks are looking at me saying, you know, what about defense? And you're right. I'm usually funding cases where it's the patent owner asserting its patent against one or more defendants. But in the pharma space or in the generic space, we've worked with clients whose legal risk is on the defense side. They need to often invalidate or show that they don't infringe certain patents so that they can get their product to market and monetize. And to Stephanie's earlier point about alignment of incentives and what folks' interests are, there's certainly a good overlap of interests and incentives on the defense side, but you're also working with enemies to a large degree. And so being able to identify where those interests are going to diverge, if and when there's going to be a splintering off of defendants, and folks have to figure out what's in their own best interests and leave folks, I'll say, hanging in the wind sometimes. That's a challenge that needs to be navigated almost on a minute-by-minute basis, and certainly as folks get closer and closer to trial. So I'm not quite sure if that brought it back to the beginning, but I'll hand it back to Gene at this point.
Yeah, I was gonna ask you to explain, so we can just start with you if you have a minute to follow up on that. You do fund these types of situations, right?
Sure. And so again, getting back, I'll say to the more readily recognizable, or I don't want to say standard, but more traditional litigation funding. Most folks look at patent litigation and say patent owner has a claim against a infringer or infringers who are making, using, selling a variety of attractive products, and through litigation there's either a settlement that generates dollars or a jury verdict that generates dollars, from which a client sees dollars and the litigation funder sees dollars. In the defense scenario, on the, I'll call it the Hatch-Waxman sphere, you've got a patent owner who's asserting its patents to keep the generics off the market and maintain its own monopoly position, which is, I'll say, a fundable opportunity. But from the defense perspective, you've got one or more defendants who are saying, if we could only bust these patents, if we could only prove non-infringement, we could finally sell our product and finally monetize. And different generics are at different, I'll say, life cycles of their companies, single products, multiple products, huge portfolios. Having an opportunity to have them de-risk their litigation and have that risk shed over to us provides the defendants with an opportunity to say, we can now focus on what we do, which is R&D on our next generic product, let the litigation funder handle that, and when we sell our product, everyone's happy.
Okay. So one of the things that we wanted to talk about specifically are the types of things that can and will go wrong. And Brandon, I know that you had a story, or a horror story. I don't know whether you can tell exactly that horror story or sort of a hypothetical based off of that horror story. But it might be good to get that out so people know what it is that we're thinking and what we want to talk about.
Sure. I think I can give a lot of the details. This was a while ago. You can maybe piece together the case. But it was an ANDA case, so there two defendants. In terms of working together, the two law firms, we had a great relationship. You know, we divided tasks evenly, prepared for discovery, depositions, preparing for trial. Everything went smoothly, or so we thought. This case was, we were trying to invalidate a molecule patent. it all hinged on whether or not the molecule itself or was the API, or whether when it was introduced into the body, it converted to its free acid, and that was what was actually being the API. There was a lot of literature out there, but it was kind of inconclusive, and so it was, we thought this was a molecule patent case that we could win. We got to trial. We were setting up in our war room in the hotel with the other law firm down the hall, and they told us they wanted to talk to us. And their lead counsel, who had not been involved a whole lot up until that point, specifically wanted to talk to us. And that's when they dropped a bombshell that in their ANDA application, they had, in multiple paragraphs, said that the mechanism of action hinged on the molecule. And there weren't qualifiers in the ANDA that this is what the art said or this is what the brand says. It was just more of like, this is what happens. And so we learned 2 days before trial that they had made statements that completely undermined our obviousness argument. And on top of that, because we didn't know about it, our obviousness expert didn't know about it. So we tried to prep for him to get on the stand and deal with this, but it did not go well. And we lost the trial. And there are some other reasons why we may have lost, but this was a huge part of it. And in retrospect, I mean, the statements were there, but we could have been telling our client, like, here are your litigation risks from the start, as opposed to telling our client when the trial was about to start that this is a huge obstacle and changes the dynamic of this trial completely. So I don't know what we could have done to ferret this out earlier, other than just asking our co-defendant more frequently, like, hey, is there anything that we should know about that might be in your ANDA or that you know about that might undermine this case? And if we started getting some answers that evaded our questions, we might have had a better idea of what to expect.
So Phil, you've been on both sides of this, both as a litigator and as the client. What do you do when something like that happens? I mean, a couple days before trial, there's probably not a lot you can do, but what are you thinking about trying to do to mitigate bad news like that?
Well, one thing that you should do at the outset, and I should add, I also have worked as an expert witness for multiple defendants in a litigation and seen the dynamic from that perspective. One of the things you can do at the outset is to try to verify as much as you can with the other co-defendants with whom you'd be cooperating what areas you have a community of interest, a real community of interest, and what areas you may not have. For example, in the Hatch-Waxman context, the generic products, one to the other, may be somewhat different, and one or both of the parties might have a non-infringement argument in addition to an invalidity argument. And claim construction, the claim construction that each may want, may be quite different in order to have it broad in the area where they're hoping to get invalidity and have it narrow in the area where they're hoping to have non-infringement. So I would say at the outset, do everything you can, even to the point of perhaps, if you're worried about confidentiality, getting a third-party counsel, hire a third-party counsel to come in and review the documents that you don't want shared to be sure you don't have these conflicts. And then if you hire an expert, make sure that the expert knows in advance what the parties have agreed as the issues to which the expert is to direct his or her attentions, so that you don't get into a situation that you might think of as expert creep, whereas you get close. I see Sherry smiling. I think must have happened. She works as an expert frequently, where you get expert creep, and as you move towards trial, the litigators say, gosh, we don't have anybody who, we don't have any witnesses who will say X. And so they go to their trusty expert and try to, hey, you know anything about X? You think you could testify? you don't want to get into those situations, especially where, well, it may happen, but there are several reasons. One thing is, if you've picked out your expert for what your expert is really expert in, you don't want to stretch them into an area where they could be cross-examined and reduce the expert's credibility on what the expert's really expert in. So don't try to have the expert put Band-Aid brand Band-Aids on areas of the case which are weak.
So
I
now,
could go
just,
on,
just
but-
no, but just so everybody knows, Band-Aid is a Johnson & Johnson brand. And so that didn't fly over my head. I just wanted you to know I caught that.
Yes, actually, I think it's now exclusively licensed to Kenvue, but yes.
Yeah. That's great. I love it. So Stephanie, hearing these horror stories, I think you have some horror stories in our medical device area, maybe, or
All my cases go perfectly, Gene.
yeah, no, I know. So maybe you're talking on behalf of a friend.
Right. Hypothetically, I don't have any horror stories like that where you sort of wake up and your trial story is completely different than what you thought it was going to be. I think one horror story that every defendant in a multi-defendant case worries about is the person who's carrying the water on X task settling out and leaving you empty-handed. And that is terrifying. And the point, or one of the benefits of a joint defense group, is that you're sharing costs and sharing the work. That's the benefit to your client. As lawyers in private practice, right? Like we want multiple brains thinking on the same issue, but we're splitting the work. And you have to trust that your co-defendants aren't going to settle out, but you can't trust them. You're frenemies in this circumstance, and that's sort of terrifying. So I think checking in with your co-defendants all the time, and when you start getting radio silence about things that they should have answers to, you know that they're probably settling and they just are ignoring you because they don't want to have a conversation that's awkward. But yeah, I mean, that's happened to me pretty close to an expert deadline when your co-defendant settles out and they were carrying the water on a big part of the expert report, and buckle up because your team gets to pick up the slack. So I think that's one hypothetical.
So Brandon, you represent patent owners, not exclusively, but a lot, right?
A lot now, yes.
Yeah. So what do you do to try and create that friction and tension and get their side to fall apart? Because I know when I was representing plaintiffs, you would purposely try and pick people off. And, you know, it was funny how they were all united front right up until you offered one of them a good deal.
Yeah. I think there's ways you can lay the groundwork from the beginning. You can maybe get us, like when you have calls with co-defendants and you're trying to work out discovery issues, you can kind of get a sense of who is taking the lead on things and who is not, or who might not be paying attention as well as another defendant. And so if you have an opportunity to have a one-on-one call with one of those defendants, maybe you can try and flush out some extra information from them, get a sense of, like, if you're talking to one of them and you ask them some basic questions about what they plan to do with documents or depositions, and that person can't tell you, and they say, well, let me talk to the rest of the group and get back to you, you get a pretty good sense that they're maybe not as invested as others. And so maybe you can start to hone in on them and find a way that maybe you can even glean extra information from them, because some people have looser lips than other people.
Mm-hmm. Now, could you also then know, okay, well, this person's not carrying the water, so if I let out somebody who is carrying the water, then I'll finally be able to have a come-to-Jesus conversation with that guy or gal?
Sure. If you have a defendant who's been difficult and you get rid of the one who's leading the charge, then yeah, that can definitely be leverage for you to get something more favorable.
When I was a brand new attorney, I was second chair on a case, and I told the partner, I was like, the party that we need to let out of this case is party X. And he looked at me and he said, well, that's the party that's most liable. And I said, I know. I said, so let's cover all of our costs, get enough of our money out of them, and they'll be glad. And I said, and if you do this during mediation, he had a mediation coming out, I said, I'll bet you that by the time you get back to your office, you have a call from the other party who's been saying, we're never going to settle this under any circumstances. And then sure enough, he came into my office, he sat down in my office, told me how the mediation went, and his secretary comes in and says, "You have a call from party Y." And he said, "That's them." And the whole case was settled that day. So there are ways that you can play one off the other in this scenario. Not that you ever did that, Phil, right? Did you ever do that? Or did you ever get played?
Well, look,
I'm sure you never got played because you spent too much time on the other side. You probably would see it coming, right? I mean, and I mean that seriously. So maybe working, what are the telltale signs that this is about to happen? Like Stephanie just mentioned some of them.
I mean, in our field, the track record is 96% of the cases settle.
Right.
And so there are lots of variations when you're dealing with competitors. We work in complex situations in medical devices and pharmaceuticals, and you're dealing with one of your competitors with whom you have a relationship that extends for some time. Different competitors are going to have different patents or properties that you might be interested in licensing. You have a lot of arrows in your quiver if you want to start negotiating with some of them. And the dominant and driving force is normally what is a reasonable settlement for this party. And a reasonable settlement for party A might be quite different than for party B, depending on the fact situation. But certainly, you do know that it can be beneficial to settle with parties if it's going to strengthen your position in court. And I would say, on the other hand, if you're a defendant, one of the advantages of sharing an expert between different parties is that expert's going to stay available if you need them in court. So you don't want to be in a position where when your co-defendant settles, or one of your co-defendants settles, suddenly you've lost an expert that you were relying on. But the same thing goes for witnesses. Often the witnesses that you're planning to have at trial, who are critical witnesses, may be witnesses who are not within the subpoena power of the court, but within the control of the settling party. And you should be thinking about that when you're doing your joint defense agreement. Otherwise, you're going to be stuck with playing a deposition, a video deposition. And often that video deposition isn't going to be able to cover the topic the way you would want it covered at trial.
Or worse, reading a transcript, which is never fun for anyone.
Right.
Yeah. So Josh, when you're trying to decide what cases you want to get into as a funder on this level, this has to add only an increased layer of complexity for you. I mean, it seems like, I don't know how you fund these cases. I mean, because it's three-dimensional chess to begin with, and now you're adding an extra variable.
Working with multiple defendants, in good times can be like herding cats, if that's not an insult to cats. But I don't mean to be reductive here, but trying for folks to keep a mind on the goal and to be prepared, sort of like a scout, right? Both prepared on our end and knowing as much about the matter as we can, but also the defendants and our client being eyes wide open in terms of, I'll say, what role they expect to have in this joint defense group. Trying to understand market dynamics and who else might be looking to get into this space. If we're looking at an early opportunity, we're perhaps in no better circumstance than the client itself. Is the client going to be the only paragraph 4 filer? Is it going to be one of 24 filers? And how is that going to impact the future arc of the case? Folks are talking about having experts disappear, witnesses disappear. Part of this, when defendants settle out, is there going to be a domino effect where a keystone defendant leaves and others follow? They know at the outset that they're going to only go as far as defendant X, and as soon as defendant X is out, they're out. And that has impact not only on the witnesses that are shown in the evidence that's available at trial, but on the attorney burden. And being prepared to say, we either need to get out of this case or we need to bring it all the way to the end is part of this. If you are sharing the load across 2, 3, 4 sets of counsel, and different counsel is prepared to direct or cross a witness, and suddenly they're out, their client is out, they're not going to be in that courtroom. Someone else who remains is going to have to pick up that slack. And budgets are not limitless. To Phil's point earlier, hiring additional experts or having additional resources is great, but no defendant's pockets are bottomless. And you have to keep in mind, how much are you putting into this? How much is it benefiting, I'll say, the entire group while also benefiting yourself? And what are the returns going to look like? You can continue spending, but if every dollar you spend is only going to help you 1/10 of a dollar, it may not be that interesting to you anymore.
So can I piggyback off
Sure,
of that?
go right ahead.
I think you're right that this is in some ways three-dimensional chess, and maybe the smarter play is to just assume that someone's going to settle out, and you need to structure your joint defense group, your joint defense agreement in such a way that you can maintain control of your experts if you need it and things like that. And also staff, if you have a big enough group, so that someone else is like the second pair of eyes looking over something, so that you're only really in trouble if two people settle out and they were the ones that were in charge of a single issue. Sometimes it's not feasible if you have a 2-member joint defense group. Well, then you'd just be doing everything. But recently I was in one that had 9 defendants. Well, we had enough of a luxury, we have enough attorneys that we had the luxury of being able to staff a second pair of eyes on everything, so that when someone did settle out, there was at least someone else in the group that was marginally prepped on these issues, or at least felt responsibility for them. But I think, it's not a question of if someone's going to settle, it's a question of when. And so the better practice is to just be prepared and protect yourself along the way, and be able to let go of some issues too if your client is amenable to that, because budgets are not limitless. And if someone else was raising a defense, an invalidity defense that your client doesn't love, let it go, assuming your client is willing to do that. I think those are the better practices than trying to predict when your co-defendant's going to settle out, because it could happen whenever.
So when is it that you want to have, for example, the same expert when you're in this situation? And when is it that you don't want to have the expert? And the reason that question comes to mind at the moment is because I believe during our pre-call, we also discussed the possibility that the expert was hired by a particular party, and then others are just kind of me-tooing with that expert so they don't have to pay the expert. Well, the party who primarily hired the expert settles. I mean, this creates, it would seem to be a enormously problematic dynamic. Do you want to start, Steph?
Sure. So this came up in one of my cases, which was not a pharma case, but I think it can still be applicable to things like the med device space. It was the manufacturer, who actually wasn't a party to the case, that wanted to hire the expert, retain the expert, and just let its customers use the expert's work product. So my client wasn't, according to this sort of like quasi-indemnity deal that was happening, not able to actually retain the expert. Well, that raises all kinds of issues on privilege. How is this expert getting prepped? If the expert's work product is being used amongst 9 different defendants or 5 different defendants, whatever the number is, are all of those defendants' interests aligned with the entity that's actually retained the expert? Probably not, because there may be different non-infringement positions, but there may also be different invalidity positions that are in tension with those non-infringement positions. So how the pieces fit together in a particular case, I doubt that multiple defendants are going to be aligned in every way. In fact, I don't know that I've ever been in a case in which everyone's interests are aligned on every position. So sharing an expert's all fine, except where the interests diverge, and when you don't have access to the expert in a way to suss out where these tension points are going to be because your client's not the one that's retained the expert, that's terrifying. But then also what happens if the manufacturer wants to settle but hasn't yet, but doesn't want to pay the expert, but your client's facing a trial deadline? I mean, these are all sort of worst case scenarios that thankfully didn't come to play in my case because everybody settled relatively about the same time, but it was a hard business call, I think, for my client to decide to want to take the help that the manufacturer was providing, because there were a lot of strings attached and we were not in control of our own defense. And this was going to be an expert that was going to serve on a single patent in both an invalidity and non-infringement capacity. So then, you're really screwed if this expert goes sideways for whatever reason. There's also issues about depot prep. If if there are slightly different non-infringement stories for different defendants, you may not be able to be in the room while the expert's prepping with your co-defendants. But then you might end up with a situation like Brandon had, which is you get blindsided because there's a position that you can't work around from the beginning. So,
Yeah. I mean, to add to some of that, the answer, like most things, depends. There are pros and cons to sharing and not sharing. In a different case that I had, it was 4 defendants. 3 of us all wanted to use the same invalidity experts, the obviousness and then secondary considerations and things like that. And then there was one defendant who wanted to do everything on their own. And
Scary.
throughout the course of the case, we became more and more concerned about the quality of work coming out of that 4th firm and that 4th defendant. And so, without trying to be too heavy-handed, we asked and then started to demand that we won't be involved with writing your expert reports or working with your expert, but let us sit in on your meetings with your experts. And then especially when we got to deposition prep and then closer to trial, we worked it out so that we could at least be a fly in the room to get an idea of what those experts were going to say. And frankly, there was one expert that terrified us because when he was prepping for his dep, it seemed like he remembered none of the things that were in his report. From one page to the next, it didn't seem like he had paid any attention to his report. So we went to trial in this case. Most of the experts did well. That guy, before trial, we spent so much time with him, and we tried to be more hands-on to prep him. And I'm still shocked to this day because he blew it out of the park. When he was on the stand, he was amazing. All before that, he was a train wreck. So things can go bad or things can go good. But just trying to have an idea of what if you're not sharing an expert, trying as best you can to have an idea of what that expert's going to be saying is critical.
Phil, as the expert on the panel, what say you? Should they be hiring the same expert? Should they, or should they hire you and another person hire Sherry? And I think for both of your sakes, the answer is yes, right? You should all be hired all the time. And
Early and often.
Early and often. But
I think that what you want as an expert, if you're representing multiple parties, is you want to be sure there's really a community of interest as to the issues that they're asking you, which is why I started by saying you want all the parties involved saying these are the questions that you are being retained to answer. And you want to be sure that there is alignment between them so you don't get into a situation where you have to make a judgment where you're talking perhaps about, I don't know, a claim element or something else where one way of interpreting is going to help one of your clients but hurt the other one. You can't get yourself into that situation, and if it looks like it's going that way, you should
Gotta get out.
You've got to say, I'm sorry, that's not what I was retained to do, and that's not what I think you should have me do.
So, and I say you got to get out, but that's because I know you're a lawyer. You're still admitted, right? And Sherry, and I say that simply because I know now you're retired and you're doing other things. I assume you still hold your card, right? So you still.
You're the only one who thinks I'm retired.
Right. Right,
My wife, whose birthday is today, would think otherwise.
Yeah, no, I know. You've moved on from Johnson & Johnson.
Yes.
So, but you still hold the same ethical ball and chain that other lawyers do, and Sherry does as well, and many of the other people in the room who would be experts would. Is it different? And I think I know the answer. I don't want to seem like Pollyanna share, but is it different when the expert is not a lawyer? When the expert is, a scientific expert or a technical expert, are they the ones that are more likely to say, sure, what do you need me to say? What sentence do you want me to add to my report? What do you want? Yeah, I'll represent your client. And sure, Brandon, yeah, there are no extra costs that they're paying me. Is that more likely from someone who's not a lawyer and doesn't have the ethical ball and chain, or does that ball and chain not attach when you're in the role of expert?
Well, I think if you're worrying about whether what you're doing is ethical or not ethical, you're already too close to the line.
Right. No, I say that, because I say that
it's-
in the patent world, the patent office did not adopt the ABA model rule for fraud, for the meaning of fraud. And it's the common law rule. And I say that if you're arguing that it's fraud under this standard, but certainly not fraud under this standard, you got a problem, right? So these are all problems, and I would think lawyers would see them coming and handle them differently. Am I wrong?
Yeah, well, we've all worked with technical experts of one kind or another, and the concern with the technical expert or other types of experts is, do they understand the case well enough in order to direct their testimony to the subject matter for which they've been retained? The scary part is when the expert gets on the stand and he says something like, "Oh, does that question bring back memories? I hadn't thought of it till now, but," and you just want to die as counsel.
Yeah.
So yeah, I think lawyers tend to understand better what's at issue, what's germane, and both in focusing the testimony and in not getting into trouble by running off on something that they really, it may not be that what they talk about is untrue, but they're not prepared for it, and they can open themselves up for cross-examination of various kinds, including, did you prepare for this? Did you look at the relevant documents? What analysis did you do? And if they're just shooting from the hip, then everybody's in trouble.
Go ahead.
I would add to that, by and large, the technical experts I have worked with want to be correct and want to dig into the materials. And so they don't want to be caught off guard, and they're the experts here. So if you propose something to them and they say that's not going to fly, they're generally pretty good about telling you that.
Right.
And if they're not that type of expert, if they're the yes man or the yes woman who's willing just to go along with anything, you kind of get a good idea of that. But I don't know what it says about me that I have all these horror stories. But I had yet another case where we came in later, and the first defendant had already picked an expert, and our client wanted to go along with this expert, and he had a lot of moral failings, but he was willing to say whatever he wanted to say, and it turns out he had said other things in the past that were completely opposite, and that came out at trial. And then years later, I learned that he was prosecuted criminally for stealing his grad student's work and claiming it as his own. So you get a sense of that person. By and large, though, technical experts, they want to get things right, and they don't let you push them around.
Well, the good ones don't, right?
I would say, though, the more persuasive witnesses in those areas are the inventors and technical people, and the story that led to the invention if you're on the patent side, and that you shouldn't try to substitute your experts for those areas where you really need the compelling nature of fact testimony from the people who were involved in the transaction.
So let's turn this a little bit to a cost-benefit analysis, right? We're talking about, should you have the same expert, should you not have the same expert, that sort of thing. Listening to you, Stephanie, talk about a situation where you may not even be able to even be in the room while one of your co-defendants is prepping the expert that you're going to be using. And I get it on face value why that is, but I would personally, if I was chief IP counsel or general counsel at a company, and there would have to be enormous cost savings to make that cost benefit risk worthwhile for me. I mean, because you don't know what you don't know, and going into this, you can't be included for a very specific reason.
Right, the exact reason why you would want to be included, so that you avoid a bombshell like that.
Right,
being dropped on
exactly.
you. Yeah.
And you can't possibly be prepared for that which you don't know. But the system is set up so that you, on the defense side, you can't object when your co-defendant does something stupid at trial and asks a dumb question, or the expert's not prepared on that issue, or says something that goes against you, right? I mean, you can't jump up and say, I object.
Right. So I think in this case, there were multiple layers of technology providers involved that created a dynamic. And I think your client also has to weigh their own exposure, right? I mean, if this is a case where your client knows from the get-go they're going to try to settle out, they don't want to take this all the way to trial, or that one of their technology suppliers is going to indemnify them and help contribute to the settlement. I've gotten this before from clients like, don't worry, we're not going to get that far. It's not that big of a deal, which is terrifying. I'm not saying that we make legal judgments based on that, but I do think you have to evaluate the overall picture. How important is this going to be to you in this case? In the case that we had an expert sharing conundrum, there were multiple patents in the case, and this was one patent. So yes, that was an important piece, but we also had 7 other patents to worry about. So that wasn't going to make or break the ultimate case, because for that specific patent, my client wasn't that exposed, et cetera. So I think there's lots of different things that go into the business calculus for your client to decide whether they're willing to accept an arrangement like that. So it wasn't just cost savings, because I agree with you. If it's just about, do I pay a fifth of the expert's bill or half the expert's bill, that's probably not enough incentive to take on that kind of risk.
So, sometimes you're also limited by your market too. So if the plaintiff has already retained a few of these experts
Yeah.
in the same field, and then you've got some co-defendants who have retained some experts, and then maybe there's conflicts because some certain people in the field have done work for one party or another, you may have the choice of either agreeing to go with another defendant or taking an untested new expert who might shine on the stand or might flop. And so that's part of your calculus is, do you pick a new one, or do you go with one that you can share and maybe there's some issues, but at least you know that this expert has testified before, has done well, and could do well for you.
That's true. We've had that situation too, where you don't have very many choices, and if you want to file an IPR, you got to use one potential expert in an IPR, for example, and you don't have any options.
Mm-hmm. So, Josh, what do you say about this? I mean, so you're the one funding this in some instances, and we talked a little bit during the pre-call about how the existence of funding might make that particular defendant a little bit more bold, and maybe not as willing to take a deal, a reasonable deal, perhaps, or it may even embolden others who knows that this defendant is being funded, so I can ride coattails. And then you're paying for this to a large extent, and you can't hear what the expert's going to say on the stand when Brandon asks him a question or Stephanie asks him a question?
Well, let me work backwards into that. I find myself in the unenviable position of not even being able to understand what the expert's saying about anything, because we're not under protective orders. We're not even entitled to understand what's going on in a large portion of the case, let alone what's 2 or 3 layers down that everyone else also doesn't have information into. But that's why I prefer, in matters that we're funding, that we have, I'll say, as much oversight and ability to say, or at least make our opinion heard to the client about what we think could make sense. Most of our cases, we're not controlling the client's actions in terms of taking a settlement or pursuing litigation. And so we need to understand who it is that we're dealing with as a counterparty, first and foremost. Are they a wild actor? Are they going to behave rationally? Are they going to simply follow some other defendant's lead? Are they going to take more of a leading role? And are they going to be receptive to the thoughts and comments that we're going to have about the arc of a case? In terms of spend, I think that folks want to get to the best result that they can for themselves. It may benefit others in a joint defense group, but they're looking out for themselves first and foremost. Whether the fact or existence of funding allows folks to act in a more bullish behavior or more of a secondary position, sort of wait and see, I think that's case dependent. It matters situation by situation, who has already sort of settled out at what points in time, what offers to settle, if any, have been offered by the patent owner, by the brand, and figuring out, is it still worth the dollars? Even if they're not coming out of the client's pocket, at some point, if you will, the client is going to have to pay a return on this. And so every dollar that the client is spending of a funded case's money, that's going to come out at some point in the future when they make their sales. So they're looking to say, maybe it's worth spending the extra money here on an extra expert or on our own expert that we would have more control of, as opposed to having defendant A, defendant B have control of that expert. Because at the end of the day, once we hit market, we're okay sharing the profits because we think our expert or our case is going to get us to that resolution point sooner. So maybe that causes them to be a little bit more aggressive in the case, or it causes them to say, this is going to make sense for us by settling out because we're going to get exactly what we want at a date certain, and we don't need to spend any more because we don't want to share anymore with the funder. Whether other defendants know about a particular defendant's funding situation is, again, that's going to be up to the defendant, the client itself, to share that information, but typically that is not, I'll say, widely revealed. A defendant's own, I'll say, abilities or capabilities, that's something that they tend to guard on their own, right? Again, you've got defendants with similar interests, perhaps on the patent merits, but revealing to your co-defendant, whether you're in financial dire straits or you've got the wherewithal to take this all the way, you might not want to let your other defendants quite know what's going on. And if they feel like they need to settle out and that gives you an advantage, that's success for the client, success for that defendant.
So Phil, any thoughts on that, or do we want to move on?
Well, it was touched on. What happens when you have the same issues being handled in two or more different places?
Right.
Whether that's the PTAB or whether it might be a Hatch-Waxman defendant, a generic that you can't get jurisdiction over, and you can't get all of the defendants in the same jurisdiction. Then when you start thinking about settlement and you start thinking about experts, do you use the same experts in an IPR as you're going to be using in court, or do you use the same experts in both courts? And beyond the experts, if you don't settle to get out of one jurisdiction or another, you'll be having your witnesses, if they're the same witnesses, including your inventors and others, deposed at multiple times in sequences that might not be beneficial for your case. So you have to take that into account. Do you have an opportunity to, say, get yourself out of West Virginia in order to have all the rest of your case heard in Delaware? And how do you handle that along with the IPR sequence?
So let me follow up on the IPR situation, because the depositions in an IPR are very different than a deposition in a litigation. What impact does that have on this decision at all? I mean, because as Phil points out, 96, 97% of these cases are going to settle anyway, but you're going to have to live with the deposition the expert in the IPR gave for a very long time, forever, really. Yeah. Brandon.
Well, I think in general it's best to share, because if you're the plaintiff or the patent owner, maybe you've got an exclusive licensee, so maybe you're both working together. But it's best to share because you can have control over it. If you're the challenger in an IPR, I mean, the deposition is much different, and so it's only invalidity, and it's usually on discrete issues, and you're not. I think there's less chance for the expert to go astray, because.
Well, let me tell you where I'm coming from here, because as I understand it, in the IPR situation, you go much more aggressively at the people you're deposing in IPR, whereas in litigation, you might want to give the expert a lot of open-ended questions and give them the rope to hang themselves. I mean, I've been in litigations where the expert didn't even know that they had hung themselves. You know, and after the deposition was over, in one particular case, the expert was handing out cards, like, you know, in case you need me, in case you need me. And I remember the senior partner, he took the card and he looked at me, he said, you can throw this away. You know, because, and that was in a case where it was about electrical engineering, and I caught what the partner took a timeout, and he called me out in the hallway, and he asked me, he's like, is what he's saying right? I was like, no, it's fundamentally wrong. He's wrong, and here's why. And so we just let him go and say whatever he wanted. Now, but that's not the type of deposition that you would do in an IPR.
Right.
And so very different uses, same procedural tool on the record, it's being recorded, et cetera. Would that make you more likely or less likely to have the same expert? And it probably is going to depend. So when it depends, what factors might you think about?
So I was trying to see how this would apply to multi-defendant, but I hear what you're saying now. And so if I'm choosing between using the same expert for, say, a district court litigation and the IPR, there's a lot of things that go into play there. One being, if your expert in your IPR can handle those tough questions pretty well in a DEP, but I just had this happen in an IPR DEP. So our expert got asked a lot of pointed questions, and he was very careful, but he took sometimes 5 to 10 minutes to answer the question. And so on a deposition transcript, you don't know that. Like, all it does is it look like at some point he's answering the question. Do I want that person testifying at my jury trial? Heck no. Because the jury's going to get bored, they're going to get lost, and they're going to think that he's hiding something.
Right.
But in an IPR, that doesn't really come out. So if your expert in your IPR is like that, then you know in your district court litigation that's probably been stayed, I need to find somebody else. Conversely, if your expert in your IPR is knowledgeable, prompt, handles questions well, and knows his stuff, then and goes relatively unscathed through his deposition, then sure, use him again at the district court.
And I suppose you have all the time in the world after the IPR, if the case is still valid and the patents still have some claims, to pick a different expert, right? So it's not like you get locked in typically, right?
Right.
Yeah. Steph?
I think that you also need to look at the issues you're going to raise in the district court and whether or not there's going to be tension between the positions you need to raise in the IPR and the district court. 112 comes to mind because you can't raise it in the IPR. And so if you have the same expert, and I litigate a lot in Texas where our schedules are really fast, and so I don't often have a stay or the luxury of more time to pick a different expert because it's going in parallel, and our deadlines are quick. But is there going to be tension between your positions? What you don't want to have happen is have an expert who's already opined in the district court on claim construction that something's indefinite then need to appear before the PTAB because there's tension between those arguments and could screw up your chances of getting institution, for example. So I think it's expert style, because I'm oftentimes willing to take more of a risk on an expert who doesn't have much testifying experience in an IPR than for a district court litigation, for example, for some of those reasons, just the style and are they going to be appealing to a jury. But there's also, I think, substantive reasons why it often makes sense to use a different expert in the IPR versus district court litigation.
Now we're going to talk more directly about the 112-103 conundrum tomorrow in a couple of panels that we have tomorrow. But I'm looking at the clock. We're down to about the last 5 minutes. Again, the time has flown. So what I'd like to do is give you guys an opportunity now to, wrap up if you care to. What is it that maybe the question will change it up just a little. I mean, I always ask, what's the one thing you hope people remember? Maybe to just switch it up a little bit is what do you hope they are considering when they're making the decision, particularly about hiring the same expert or sharing a workload? What do they need to know? What do you hope that they know going into making that decision, if they've never had to make that decision before?
As a client,
Yeah.
what's the exposure and what are your interests? And how willing are you to let others share in taking control of the issues that will impact your own interests? If this is about the company litigation for you, maybe you need to go it more on your own, even though cost savings would be nice. So I think knowing upfront what your client wants to get out of the litigation and how willing they should be to take on the risk of working with others weighed against the benefit of cost sharing is an important conversation to have that's in some ways different from or separate from the merits of the case. What is your business goal? What are you trying to get out of this litigation?
Yeah.
Yeah.
Great, thanks, Steph. Brandon.
I would say just learning as much as you can about your co-defendant and their law firm as quickly as you can. If it's a firm you already know, then you've worked with before, or a client that you know how they act, then you've got a good sense of how things might proceed. If you don't know any of that, just starting a rapport with that firm quickly and often is the best thing to do, because if the senior associates on the case start establishing a relationship where they work well together, and then the partner who's managing the day-to-day, if they're in communication and they're working well together, a lot of these landmines can be avoided. So it's just from the beginning investing some time to get to know who you're working with and to try and build some kind of trust, so that going forward, if someone is going to maybe be pulling out, maybe they don't tell you right away, but maybe they give you some kind of an indicator that, hey, like, you should be getting ready for this deposition because we might not be taking it. They won't say it, but they can give you some clues.
Right.
Whereas if you haven't been working well together or you haven't made that effort, you won't get that indication.
Yeah. Great, thanks, Brandon. Phil.
If the case matters to you, don't look at hiring an expert or sharing an expert as a way to save your attorney's fees. Keep your counsel involved and have it be a common effort where your counsel is involved all the way. And as you do that, make sure, both by getting a good joint defense agreement at the beginning and also in the way that you approach things, don't get yourself in a situation where you can't go to trial if the other defendant settles on you. Not if the case matters to you. Be sure you've got the witnesses that you need made available to you, and that you can go, if even as late as the night before, if there's an 11th hour settlement and you're not settling, be sure you don't get yourself in a position where you have to go in and say to the judge, we can't go forward because that isn't well received by the court and doesn't put you in a likely position to prevail.
Right, and there's no guarantee the judge is going to say okay.
Right. In fact, the judge is going to say, but Mr. Johnson, this is the day of your trial.
Right.
Put on your first witness.
Yeah. It's like, well, you have 90 minutes to figure this out, Phil. Go for it. Right?
My first trial was just like that.
Yeah.
In Massachusetts,
I
when I was in law school, and I was given over lunch to get my witnesses together.
I remember I had a similar situation. A judge asked me one day when I stood up before him, he was looking down at the file and he looked up at me. He was expecting to yell at the senior partner who didn't show up. And he asked me, when did you get this file? And I said, 3 o'clock yesterday afternoon. And he said to me, he said, okay, let the record reflect that what I'm about to scream at Attorney Quinn is directed to Attorney Kennison. And he did scream. But, so, all right. So, Josh, and thanks, Phil, but Josh, your final word.
Whether this is helpful or unhelpful, I suppose, right? You get what you pay for. And as long as the client is paying attention and is as prepared as possible, sometimes it makes sense to go it alone, make sure you're in control, in as much control as you can, and sometimes it makes sense to do some sharing. And I think we've heard a common theme here today, which is sharing and bearing that burden together makes sense as long as things are going well. But at any moment, whether it's before a deposition or on the eve of trial, things can go sideways real fast. And when interests start to diverge, if you're not in control of as much as you possibly can, you may not have control of your case anymore.
Yeah. So I'll leave with parting thoughts. Many of you know I'm a UFC fan. Many of you don't know that I have a second-degree black belt, and so I really get into it. And there was watching some UFC the other day. They have what's called Dana White's Contender Series, where all these young or undiscovered fighters are trying to fight to win to get a contract. And this one guy during his human interest story leading up, he was talking about his plan A is to win and get a contract. And he said, and my plan B is to make plan A a reality. And I thought to myself, I was like, that's not really a very good plan B.
I think was it Tyson who said everyone's got a plan until they get punched in the mouth?
Everybody's got a plan until they get punched in the face. You know, and the thing is if your plan B is to make plan A work, in this scenario, plan A often gets pulled out from under you like a bad musician pulling a tablecloth out from under the dishes. It goes really, really badly. So you really have to have a plan B at all times because, as we know, as Phil reminded us, 96+% of these cases are going to settle. So if you don't find yourself in this situation as a defendant today, you're going to eventually, because the companies that are defendants in this space are defendants frequently. So have a good plan B. That's my final parting thought. So thank you all in the panel. I really appreciate it. Great conversation.
Thank you, Gene.
Thank you.